Most transactional attorneys look at the purchase and sale of a business from a asset purchase context, right? You draft your agreement, and then anything that happens before closing is the liability of the seller. Anything that happens post-closing, for the most part, is the liability of the purchaser.
Makes sense.
It does make sense, but it's not that simple.
Definitely is not. We had a case as a perfect example of why you need to account for more than just the corporate law in the transaction. We had a client purchased a restaurant, full gut renovation. They had one same piece of equipment. It was a press machine, make the panini sandwiches, and they kept that. That was a big component of the menu. New brand, new owners, arm's length transaction. One employee carried over, which oftentimes happens. You keep the star who knows the customers in any given area, and that employee was there for about 3 months, and he, along with another 5 employees who did not work for the new business, the buyer, sued the prior owner and the new owner for wage and hour violations, right?
And that's typically called successor liability, and it's a real issue that your transactional attorney has to be on the lookout for. And there are certain carve-outs and things you can do in the document, but from a compliance and hiring-firing perspective, there's other things you could do as well.
So the issue in that case, and it's just something to keep in mind, it's ultimately, the employee, the one that carried over, the case would have moved forward. It did. We had a very good result in that case. But ultimately, it's not that there is definitely successor liability. The courts have a factor test. But anytime you have a factor test, you have an issue of facts, which means you're staying in the case until it's over, right? So now you're paying attorney's fees, and that fact that you still have to defend this because it cannot be resolved now keeps you as a potential contributor to any settlement, right? You're another wallet for the plaintiff to capture.
And it's important that purchasers of existing businesses put in a wage and hour type audit into their due diligence process, the same way you would review the lease that's going to be assigned to you or any UCC 1 security interests that are going to be assigned to you. You also want to make sure that the employees have been paid right, especially if you are going to keep any of them on.
And you can limit it. This isn't like, never ending, another 100 hours of due diligence work. If you know you're keeping 2 employees, well, then get the wage and hour records for those 2 employees, right? It's a very specific thing that you're investigating, but the point is that there's more to it than just pre-closing, post-closing, this is yours, this is mine. There are other issues that you may ultimately win, but you're still paying a lawyer to defend against it, and a smart plaintiff's lawyer is going to include you in that case.
Contact us for more information. If you are looking to purchase a restaurant or nightclub, we're here to help.